Well, welcome to our second installment in the series of creating and ratifying the Bill of Rights. And we're joined today um, by Chris Kavanaugh from Bismarck, North Dakota, Dan Hafes from the east side of Milwaukee, Wisconsin. I'm coming to you from Holland, Michigan, the shores of Lake Macatawa. And we're also joined by John Kaminsky, the executive director of the Center for the Study of the American Constitution. And we're excited about our agenda today. As normal, we're going to go a half and half. 45 minutes, we'll have some Q&A with um, John, some general kind of global type questions about this topic. And then the second 45 minutes, we'll have Chris Kavanaugh and Dan Hafes brief you on the two articles that we sent out to take differing views of Madison's motivations, as well as referencing four documents that we sent out for reading as well. As I want to be sensitive to your time, and at 11:30, if you need to go, please, that's what we've scheduled. We normally kind of hang around for another 15, 20 minutes, and you're welcome to do so, but you're under no obligation. And so if you have to go, don't feel bad, you have to go. Um, Two items of business. Number one, we do have available, if you want, CEU letters to go in your files in your districts. So if you need one of those, let me know and I can send one to you. And we'll send them out each individual event rather than wait till the end. So let me know and I can send those out probably early next week. The second item of business is we earlier in the week we sent out an email that indicated that we wanted to send you a gift. We are a value added experience. We want to send a our volume one of the creation and ratification of the Bill of Rights. It's a hefty volume and it has a lot of origin material. In fact, that's the subtitle of that particular volume. Where did all this come from? So, if you've signed up and you're attending all of these, we'd love for you to have that. If you don't want that, please let us know, and we will forego sending you that volume. It saves us a few pennies, but we're fully prepared uh, to send that to you. That'll probably come at you late April by the time we get to that. So, um, the are there any quick questions before we jump into our discussion with John? I think everything's pretty clear. All right then. John, I'd like to start out by referencing the six attempts to amend the articles. I mean, today's topic is amendments as they show up in the first, in Madison's mind and in the first Congress. But few people know about the six attempts to amend the Articles of Confederation. Could you briefly explain those attempts? And secondly, do you think those attempts had any influence on Madison's thinking or the process that he went through in getting these amendments in Congress?
Yes, well, when historians look at the Articles of Confederation, they look at it with a jaundiced eye, and they all think that this is a defective form of government and was doomed to failure. And in particular, they point out that there was no separate executive. The Congress was supreme in what it might do uh, under the limitations that the articles provided, and there were many limitations. And the other thing that historians point out all the time is the difficulty, if not the impossibility, of amending the articles because it required the approval of Congress. Any amendment required the approval of Congress and the ratification by all of the state legislatures. And that was simply impossible to achieve. Several times they got close. One time they did get all the states to ratify, but and that was the impost of 1783 that proposed amendment. But Congress rejected New York's ratification, saying there were too many provisos, too many limitations on its ratification. And so Congress asked New York to reconsider its approval of the impost of 83, which New York did in February of 1787 and refused to change its ratification. So even with that uh, unanimous ratification, it failed because of the rejection by Congress. So there were different pressing needs that Congress had, which motivated the proposed amendments. And there were amendments that were proposed. There were also grants of power that were thought to be requiring unanimous approval. Some maybe only 9 states approval. And so whenever these concerns arose, you'd have this movement for an amendment. And these amendments usually fell into several different categories. One was taxation, how to raise money. Another was the control over Congress, how to regulate Congress. Those are the two most important. But there were other concerns also that were proposed. Uh, and as I indicated before, they all failed. And historians have denigrated the Constitution because of that. I'd like to look at the articles from a little different perspective, maybe a diametrical different perspective, in the sense that uh, uh, the glass is not only half full, in my judgment. I sort of agree with Thomas Jefferson. The glass is completely full. Jefferson would say that half the glass was filled with water, the other half was filled with air. So, as a scientist, he believed very optimistic, and so I look at the articles in that way. And what I'm looking at is the fact that the articles were an evolving form of government. Most historians don't look at it that way. It's quite a bit different. The Confederation government is quite a bit different in 1787 from what it was in 1781 when the articles were approved. And that's because when difficult situations arose, often the Confederation Congress would resort to some extraordinary act, maybe extra constitutional, maybe even unconstitutional acts. And they would pass these acts and solve the problem that existed. They knew what they were doing. Madison, in fact, points out the fact in the debate over the Constitution in Congress, the Confederation Congress in September 1787, Madison alludes to the fact that the Confederation Congress has violated the Constitution on several different occasions. So I'm looking at some of these. One of the things that Congress did was they established departments. Uh, at first, under the Continental Congresses and under the Confederation Congress, at first, uh, the government, the Congress ran by committees staffed by members of Congress. This put a tremendous amount of work and effort on the shoulders of members of Congress. Some of them served on a dozen or so committees, and they were going from one committee to another committee. And remember, they're not just running the government, they're fighting a war at this time. So these are very important activities that these committees are considering and administrating. Uh, uh, what they do in 1781 is to establish 3 executive departments: finance, foreign affairs, and war. And these are to be chaired by non-members of Congress. They, in essence, are creating separate executives. Uh, and historians don't see that. They just say there's no separate executive. There's a president of Congress, but the president of Congress, annually elected, is usually no more than like a speaker of the House of Representatives, just presiding. And in fact, that's what the word president means at that time, is to preside. It's not a very does not reflect a very high office, really. But these separate departments become very important. Superintendent of Finance is Robert Morris, and he follows the tradition, the English tradition, in that the First Lord of the Treasury in England is usually the Prime Minister. And so, in this sense, in America, Robert Morris becomes the de facto Prime Minister of the United States. And so there is an executive, somewhat separate from Congress. Uh, Morris has the ability to anger people and make people afraid because of his high-handed methods of administration. He also has an assistant, Gouverneur Morris, who is viewed by many as immoral. And so the two of them together run into trouble. And when Robert Morris, one too many times, threatens to resign, Congress says, yes, you will resign. We'll accept your resignation. And when he is uh, dismissed in this sense, Congress creates the Board of Treasury, a three-man board. Instead of having a superintendent of finance, too strong, they create this board, three members, one from the eastern states, that is the New England states, one from the middle states, and one from the southern states. Uh, John Jay is then appointed Secretary for Foreign Affairs, and Jay becomes the de facto Prime Minister of the United States. And he serves from 1784, late 1784, until 1789. And in fact, he continues as acting Secretary of State under the Washington administration. He's serving as both Chief Justice of the United States and acting Secretary of State until Jefferson arrives in New York City in 1790 and assumes the role of Secretary of State. And so I've written an article on this to see how influential Jay is in that role as de facto Prime Minister. Quickly, I should mention a few other things. Uh, Congress proposes an amendment to the Articles that would apportion federal expenditures on the basis of population, counting three-fifths of the states of the slaves in that calculation. This is in April of 1783 that this is proposed. It's adopted by 11 states. Rhode Island and New Hampshire do not adopt it. And yet, because Congress is unable to use the value of property, the value of land, which is what the Articles requires for the apportionment of expenses, the states have not properly submitted their evaluations of their land. So Congress doesn't have any a foundation which they could apportion expenditures. They opt for this population as the method adopted by 11 of these states. Because Congress has no other means, in 1786 and 1787, it uses this amendment uh, uh, in establishing quotas of requisitions for the states. Everybody knows this. Everybody knows that the unanimity has not been achieved, and yet Congress still goes ahead and uses that amendment in its apportioning of quotas of requisitions among the states. Congress proposes seven amendments, considers seven amendments to the Articles, very important amendments that would have alleviated a great deal of the problems of the Confederation. One of the amendments would have provided that grants of power would only take the vote of 9 states in Congress. Another provided that 11 states would be sufficient to adopt amendments to the articles. These would have been very useful. But just as they were about ready to send these amendments to the states, it became public that John Jay had gotten a change in his instructions in negotiating with Don Diego de Cardoque, the Spanish envoy, in negotiating the right of Americans to navigate the Mississippi River. This raises all kinds of sectional issues, and those amendments that would have strengthened Congress are dropped. And so you can see the direction that they were going in, but they just couldn't get over the last hurdle. The land ordinances that were passed, considered in 1784, and then passed in 1785 and 87, the Northwest Ordinance. The Northwest Ordinance is considered one of the great accomplishments of the Articles of Confederation, and yet there's nothing in the Articles of Confederation that gives Congress the authority to enact legislation governing those territories. And so this is the one of the provisions that Madison says Congress has violated the Articles in passing these amendments. The Northwest Ordinance is an amazing act. It provides for the prohibition of slavery in the Northwest Territory and provides a fugitive slave clause. These are two things that become extremely important 60 years later. It's the power of Congress to prohibit slavery in the territories that pushes these southern states toward secession. And it's the fugitive slave clause of the Constitution, motivated by the fugitive slave clause in the Northwest Ordinance, that gets the Fugitive Slave Act of 1850 passed, which is one of the contributing factors to the Civil War. So this Northwest Ordinance is very important. And finally, I would say the approval of the call of a constitutional convention by Congress in February 1787, and then the transmittal of that new constitution to the states in September 1787 are both somewhat extra constitutional. These are beyond the Articles of Confederation. And in fact, the new Constitution doesn't call for the approval of Congress and says that the Constitution will go into effect once ratified by only 9 states, violation of the Articles. So you can see that the Confederation Congress was sort of a little footloose and fancy in its willingness to go beyond the Articles.
For those who that might be interested in looking specifics at the specifics of those amendments, on our website we have those. We can direct you there if you're interested. John, I'd like to maybe go back a little bit, because occasionally during the ratification debates, anti-federalists would reference the principles of the Revolution, kind of waving the bloody shirt, I think. But and they would say, because the Constitution needs amending because it's out of line with the principles of the American Revolution. Could you briefly explain that logic, and then do you find that claim reasonable?
Well, I'm somewhat sympathetic to the anti-federalists, I would say.
Somewhat, somewhat.
The Americans advocated the idea of federalism, a division of power between the states and the federal government. They were living that throughout the colonial period. That's what the American Revolution was fought over. Where is sovereignty? The Americans said that there's a certain degree of dual sovereignty. The colonies have control at home, and the British control the imperial policy. And the British, however, totally disagreed with that. And after the French and Indian War ended, the new imperial policy strongly advocated a very strong imperial government that was dominant over the colonies, and that was expressed in various tax measures that the Americans opposed, and then finally the Declaratory Act of 1766, which declared that the Parliament had power to rule and control the colonies in all cases whatsoever. That phrase, in all cases whatsoever, repeated often in the political debates in America, particularly over the debate over the Constitution. The second section of the Declaratory Act indicated that any act, any resolution, any petition from the colonies could be repealed by Parliament. So there's a certain sense of a sort of a judicial review that the imperial government had over American actions. The Americans felt that the Constitution might be merely substituting an imperial government in Philadelphia or New York City for the imperial government in London. They were worried about that. And they pointed out the necessary and proper clause, saying that was a new declaratory act, saying that Congress could do whatever it thought was necessary and proper. And the supremacy clause would be sort of the second part of that declaratory act, saying that and any action on the part of the states could be overruled, and anything that violated federal laws or the Constitution would be declared null and void by the federal government. So these were things that endangered this concept of federalism. The Americans also adhered to the idea of republicanism, that is, anti-monarchy. There was always a small segment of American society that advocated restoration of the monarchy, but most Americans felt that monarchy was unacceptable. Although you can see um, an advocacy of George Washington, he should be the next president, and so that rose every once in a while. Washington always stifles such a movement. Uh, there would be separation of powers is another concept that would encourage checks and balances. This was felt endangered by the Constitution, and so anti-federalists felt that these principles were endangered, whereas Federalists felt the opposite, that the Constitution was the fruition of the principles of the American Revolution as embodied in the Declaration of Independence.
When we've this topic of Madison and the fearing a second convention, but many people don't know that in Pennsylvania there was this thing called the Harrisburg Convention. Could you briefly explain what was going on there in central southern Pennsylvania? And in your opinion, did the Harrisburg Convention play into Madison's fear of what would later be proposed by Virginia and New York, the second convention?
Pennsylvania is the second state to ratify. It's the first state to consider the Constitution in a convention, but Delaware sneaks in first, then with a very quick convention. But when Pennsylvania ratified, the anti-federalists there don't give up. They continue their struggle. In most of the other states, anti-federalists accepted the ratification by the state conventions, but not so in Pennsylvania. There were some riots, the Carlisle riots, where federal celebrations were interrupted. And there was a petition campaign addressed to the Pennsylvania Assembly asking that the ratification be revoked and that the delegates to the Constitutional Convention from Pennsylvania and the delegates in Congress be chastised for their role in the Constitution. And then there was this When word came that New Hampshire and Virginia had ratified, making the ninth and 10th states to ratify, meaning the Constitution would go into effect, uh, a movement started in Cumberland County, sort of western Pennsylvania, mid Pennsylvania nowadays, but at that time, western Pennsylvania, calling for this convention to meet, which did meet between the 3rd and the 6th of September, 1788. And their purpose was to propose amendments, which they did. They proposed 12 amendments sent to the Pennsylvania Assembly in the form of a petition. And also, they were to nominate candidates for the U.S. House of Representatives, which they did. 37 delegates met from a total of 13 counties and Philadelphia. It was sort of a bust. It wasn't very successful. The amendments were published throughout the country in newspapers. Madison said that the southern states don't agree with all the amendments, and many of the amendments that were advocated by Southerners were not included in those 12 amendments that were proposed. Many of them were. I mean, the restoration of Article 2 of the Articles of Confederation, saying that the federal government, all branches of the federal government, only had those powers that were expressly delegated to them in the Constitution. That was one of the amendments. The recall of state senators, the increase in the size of the House of Representatives, restrictions on the jurisdiction of the judiciary, on the number of inferior courts, et cetera, et cetera. These were the amendments that were proposed. I think that Madison was fearful at first. I think he was relieved that the Harrisburg Convention was didn't have such resonance throughout the country. There was still a fear that such a convention, the idea of conventions, very popular at the time, but very unsettling. And Madison was particularly fearful of another constitutional convention. But I think that he was relieved that the Harrisburg Convention was not so successful.
You mentioned first federal election, so I'd like to maybe jump to that. To what extent were amendments an election issue for the first federal elections? I mean, was that the primary issue? Were there others? I mean, how prominent were amendments if you were running for office in that first Congress?
It depends. If you look at uh, the public debate in newspapers, uh, Massachusetts it becomes a very important issue. Uh, the debate there was that Federalists had sort of promised that they would seek amendments to the Constitution if the Constitution were ratified. And in fact, the Massachusetts Convention does propose recommendatory amendments. Other states, 6 of the states, propose similar type amendments. Some of the amendments are quite extensive, uh, particularly in New York and Virginia. And those amendments are copied in North Carolina as well. Uh, but in most of the other states, it's not a central issue that's there. There will be uh, opposing candidates, Federalists and anti-Federalists, and they both will argue that they're the ones that should be elected, and they would uh, be the best to serve in that capacity. Madison says that it was important. Amendments were important. And if the candidates did not promise that they would seek amendments, good chance that they would be defeated and that anti-federalists would control Congress. As it turns out, they had only 2 of the U.S. senators were anti-federalists, and a relatively small number of anti-federalists were in the House of Representatives. Madison himself, however, felt that concern. He was serving in Congress, Confederation Congress, at the time of the first federal elections. The Madison had been defeated for the U.S. Senate in the uh, Virginia Assembly, the Virginia House of Delegates, largely through the efforts of Patrick Henry. And Patrick Henry continued his efforts against Madison in his candidacy for the House of Representatives. And Patrick Henry, uh, um, uh, gerrymandered, we'd like to say he Henry mandered Madison's district, including a lot of anti-Federalist counties in Madison's district. And Madison was encouraged to come back and campaign. He was told, "You may not be elected if you don't come back." And his opponent was James Monroe, who was sort of a mild anti-Federalist and a mild anti-Federalist who favored amendments. So Madison did come back and campaigned in the winter of 1789, 88, 89. He, in fact, got his ear was frostbit, and one he liked to refer to that as the only scar he had suffered in battle. But he was pretty easily elected once he published in the newspapers letters saying that he favored a Bill of Rights, and he came back and campaigned favoring a Bill of Rights, and consequently he was elected. So, if you believe Madison, it was an important underlying issue in that first federal election.
Well, Sam had a question going back to the Pennsylvania rumblings. Is there any linkage between those folks at the Harrisburg Convention and eventually the Whiskey Rebels? I mean, I think the Whiskey Rebels are a little bit further west, but are there, in your estimation, is there any linkage there between Harrisburg Convention and the Whiskey Rebels later in the early 90s?
Uh, some of them are the same people, but I think it's a carryover. I mean, many of the anti-federalists in Pennsylvania in 1787, 88 feared the taxing power of the federal government. And obviously, that was the issue in the Whiskey Rebellion. So I would think, yes, some of them are the same. One of the most prominent individuals, William Petrigan in Cumberland County, is involved in that the Carlisle riot of December of 87 and the petition movement. And he's also involved in the Whiskey Rebellion later on. So, yeah, there is a connection.
If we accept Madison was fearful of a second convention, do you think it's a big gamble on his part to only propose rights amendments in the first Congress? It seems to be that it seems to me that he's taken a gamble on that.
Well, I'm sure he believes that's the case. Uh, but the alternative, the fear of a second constitutional convention, the fear of that was because of the danger of changing the structure of the Constitution, maybe obliterating the Constitution totally and getting a new Constitution. And in fact, the Anti-Federalists were warned, maybe you'll get even a more stringent Constitution in this second Constitutional Convention that might be called. But Madison had this profound fear of a second Constitutional Convention because of the possible amendments that would come from it. So if he put those amendments, if he advocated them himself, he was sort of giving up. He was allowing the Anti-Federalists to have their victory at Madison's own instigation. And so Madison, on numerous occasions, talked about his duty that he had because of the uh, Virginia Convention, in which he assured Anti-Federalists that Federalists would not walk away from the proposed amendments that were being put forth, particularly in Virginia. Madison said that in a speech that he gave, answering Patrick Henry, who said that Federalists would walk away from those amendments. Well, Madison did walk away from those structural amendments, those 20 structural amendments that Virginia proposed. They're not in Madison's amendments. Only the Bill of Rights, the rights type amendments, did Madison pursue. And so I think it was a calculated gamble on his part. But Madison was an astute politician. And I think he saw in his own district the vehemence of the anti-Thurus, how that was moderated by Madison's advocacy of a Bill of Rights. And I think he rightly understood if he would propose that Bill of Rights in Congress, and if they would countrywide consider those amendments, that would diffuse a lot of the opposition. That's sort of the theme that Ken Bowling has in his article, A Tub to the Whale, that those amendments proposed by Madison, rights type amendments, would be a diversion away from the anti-federalist advocacy of structural amendments. So it was a gamble, but it paid off, obviously, for him.
Lucky him. Lucky us. I'd like to go international here for a little bit. Did this debate in this process, the debate about adding amendments, did it capture the attention of European nations in politicals?
Most Europeans and European nations uh, didn't care much for America, didn't consider America very much. America was not very important in their eyes. It's hard for us to believe that, but if you can, this nationwide debate over the Constitution in America hardly has any resonance in Europe, and so the foreign diplomats that are in America are writing back to their governments, the French, the English, the Spanish, the Dutch, Swedish. Uh, Word is getting back as to what's going on. The French diplomats are the most knowledgeable, the most sanguine, the most understanding of what's going on in America, and their communications are very astute, and they're good to read, and you can see what they're thinking. I would say, except for Lafayette, most Europeans are not that concerned about the debate going on in America. Lafayette is quite concerned. He wants to have a Declaration of Rights in France. He communicates with Jefferson about this. And so Lafayette is the one man who stands out, I think, in Europe, who is interested in the debate over the amendments.
We're going to be transitioning here to a discussion about the articles, but just for fun, um, when you think through all those amendments that were sent along as recommendatory, are any of them just kind of goofy or odd? We did send out a chart of all of those to the teachers. I think earlier in the week we sent that out. But do any of those just catch your attention as just downright odd?
Oh, we sort of are amused at the Pennsylvania uh, protecting the right to hunt and fish and fowl on federal lands. And so that becomes one of the reasons to protect the right to keep and bear arms. And so that's they, the recall of senators. It's an important issue, but we look upon that as sort of strange. The inclusion of a religious oath for office holding, we look upon as a bit odd, and yet that was a major issue in some of the states, particularly in New England, uh, uh, and so that's a issue that's worthwhile to look at. The denunciation of the doctrine of non-resistance. I mean, that's sort of an amazing doctrine, but it's the opposition to that, protection against that in the Virginia and Maryland amendments is important. It had been in the New Hampshire and Maryland declarations of rights in their state constitutions. That argument, which was sort of a precursor to the divine right of kings. And so there were a lot of amendments, uh, over 200 amendments, and maybe about 100 of them were sort of unique. But most of them were fairly significant, not too much frivolous.
I want to open it up to maybe a question or two before we go to Chris and Dan. And Sam, you had another one about representation. Could you go ahead and ask that? Uh, John could
Yeah,
weigh in.
y'all were talking about how it was kind of a gamble for Madison to propose his rights amendments and not very many structural amendments. But he did have those, size of representation, congressional salary, and federal veto amendments. Were those just sort of not as structural, or was it just that the rights amendments were the vast majority of what he put forward as part of this gamble?
Yeah, I think he felt it was sort of uh, such a widespread argument on the size of the House of Representatives, and he felt that that would uh, satisfy a lot of people. He wanted to make sure that there were limitations as to the it wouldn't be too large, but he personally favored a larger House of Representatives in the debates in the Constitutional Convention, and so he was sympathetic to that. And so there were certain amendments uh, that were advocated by everybody. Uh, Article 1, Section 4, for instance. Uh, Many Federalists objected to that provision, which calls for giving Congress the power to regulate federal elections. And the argument there was that if Congress, if the states did not call elections for whatever reason, Congress should step in. If a state was occupied by an enemy of foreign power, or if there was an insurrection going on and it stifled the election, Congress should step in. Well, the anti-federalist argument was spell those out. Don't have an open-ended invitation for federal involvement in regulating federal elections. And as I said, many Federalists agreed with that too. So there were certain amendments that Madison is proposing. The right of the Congress to set their own salaries just seemed unseemly that would be there, even though state legislatures had the same authority. And so uh, Madison didn't think that they would unduly affect the powers of Congress in proposing those.
We have time for maybe one other question before we go to document discussion piece. I also might, yeah, Chris?
Well, I got a couple for John, but I don't want to monopolize things. One, I mean, your earlier comments, you said the Articles of Confederation were evolving. So was the Constitution the end result of that evolution, or was the Constitution then more revolutionary? And then my other question would be, I'm really curious about this one too, because I've seen the relationship between Madison and Jefferson described so many different ways. Just, the idea of what do you see the relationship of Madison and Jefferson? I mean, were they equals? Was Madison a protege or a lieutenant of Jefferson? One's a political scientist, one's a political theorist. I mean, I'm just curious on your take on those two things.
Yeah, well, I think they were at first the mentor kind of relationship that was there. Madison was quite a bit younger than Jefferson, younger in age and younger in experience, and so Madison looked up to Jefferson. But once Madison got involved in politics, particularly when he went to Congress, and Jefferson sort of retired from government after the death of after his uh, unseemly term as governor of Virginia and the attempt to censure him that cooled his ardor about serving in government. He sort of transferred his mantle to Madison. And with the correspondence between the two that started going strongly, Jefferson, I think, saw the power and the intelligence and the political savvy of Madison. And it became sort of an equal partnership that was there. And I think that was the case throughout their lives together. And in fact, in Jefferson's second term of office as president, one of the arguments is that he has deferred to Madison. Madison, as Secretary of State, was really acting president for Jefferson's second term, and so I think you can see the attitude that Jefferson had uh, toward Madison. In my Founders on the Founders database that I have, which is now on our website, it's been expanded greatly from the volume that Virginia published back about 15 years ago or so. But Jefferson and Madison relationship is described one point as Madison is Jefferson's elf. Uh, Madison is such a small figure, maybe 5'2", 5'3", whereas Jefferson is over 6 feet tall. And so physically, there's quite a difference. Mentally, there's a difference too. Jefferson, as you allude, is more the philosophical person than Madison, more the political scientist. And Jefferson writes with a mastery of the language. Madison, not so much. Madison, you uh, try to abstract what Madison says in a two-page letter, and the abstract becomes 3 or 4 pages long. He has what he calls perspicuity. He has the ability to say what he's thinking, but sometimes that's not done in a very eloquent fashion, as it is with Jefferson. So they are very complementary, I think. And Madison sometimes cools Jefferson's ardor on different subjects, particularly when Jefferson says we ought to have a new constitution every generation. Uh, Madison doesn't want that to happen at all.
Yeah, there's a to that point about the co-equal piece, there's a great book. I think it's Lance Banning put it
Yes.
together. These letters between Madison and Jefferson I forget the title, John, but it it shows the co-equal piece, especially when Madison's taking him to task on the, new Constitution every 19 years. He basically says you're crazy, but uh,
Yeah, I
so
think there are four different issues there.
yeah,
The first one is naturally the Bill of Rights, but how they correspond and how they differ and complement each other.
yeah. Well, at this point, let's go. Let's start with Chris. Brief us on Stuart Liebigger's Madison had noble and virtuous agendas in creating the Bill of Rights. Brief us on
Well,
that, and then we'll get to Dan.
I've got to be honest here that I'm not sure that I can full throatedly support Professor Lieberger's thesis on this. Um, I wrote down some major takeaways on the front page, and John's already alluded to this. That first, Madison was a masterful politico. He was very, very good at the politics of the day. And reading Stewart's article, I found it very fascinating, just the politics of things, especially when Madison returns to try to become a representative at the convention, right, from Virginia, and he meets with a powerful Baptist minister who I think I wrote down one of my in one of my margins that he must have like the Baptist PAC, right, Political Action Committee in Virginia, because of his advocacy for individual liberty and protecting the Baptists. But he meets with the a Baptist minister to get his support, and even as Professor Lieberger says in his article, we don't know what transpired there, so we don't know if Madison made any promises at that juncture at all. So that one of my big takeaways is that Madison was a very masterful politician. The second thing I wrote down was liberty,
I think,
liberty.
Chris, let me mention that John Leland was the Baptist minister.
Yes,
Uh,
yes.
and you referred to Professor Lieberger. When he wrote this, he was a graduate student at the University of North Carolina. And in fact, he was a student of Don Higginbottom. I don't know if you know Don Higginbottom, his writings. He wrote a lot on the Army and Washington. But I got to be very good friends with Don Higginbottom before he died. And he told me that Stewart was the best graduate student he ever had. But he was a graduate student when he wrote that article.
Well, I did not know that, but I also know that Professor Lieberger is a cutthroat bocce player. Uh, so
Yes, he is.
he takes
He,
bocce very, very seriously. The second thing I wrote down, and I think I see this throughout Lieberger's article as well as just other readings about Madison. I just wrote liberty, liberty, liberty. I think you can see this as Madison's is the idea. What's the best way to preserve liberty? The articles are not working. Let's have a constitution. Madison doesn't get what he wants in the Constitution. I mean, less than 50% probably, but he still is out there writing Federalist Papers and supporting its ratification. The threat that recommended amendments could be to liberty and prevent the ratification, and how he slowly comes around on these recommendatory amendments. I think a big thing, and John, you somewhat alluded to this, was Massachusetts ratified with the idea of accepting these recommendatory amendments, and they were quite structural. They're actually in the article. And then Clinton and his circular letter in New York, which makes its way down to Virginia, which Randolph will circulate and get a lot of folks in Virginia kind of on that train. So and Stewart writes this in his article that this kind of the second phase to preserve. Maybe this is the recommendatory amendments is a good way to go because that will win some people over to our side that were a little cool on the Constitution. But liberty, I think it was really about preserving liberty. And we can see that when he complains about the Alien Sedition Acts of 1798 as it being a violation of the First Amendment. So the idea of preservation of liberty. I think it's also interesting is the evolution of thought portrayed in the article. And again, this is the question, is it driven by the politics or the desire to protect fundamental rights or establish fundamental rights, or both? Right? I think Professor Lieberger's piece is the idea that, there's a sincere interest in protecting fundamental rights, and he tries to put that in there. I think there's a lot of history and precedents for teachers. I think this is a fantastic piece because as I found myself going through it, I'm writing some stuff from right now, as well as through history where I saw these things come into play. And if you guys have it handy, I think in my mind, and I shared this with Tim the other night. I'm sorry, on the bottom of page 456. If you have the document handy, on the bottom of page 456, I think is probably one of the most powerful passages in the essay. He said, here, Madison's idea about a charter of liberties reflected his thinking about the Constitution in general. To become effective, each needed to become venerable. A document could attain that status only through years of strict public obedience to its injunctions. And I think about kind of where we are now in our present day and how much we adhere to the Constitution or don't. I think that's a very powerful passage and quote from Professor Lieberger. The other thing I think is interesting too is maybe I don't know, is the evolution of thought or how we move from the idea of expressly delegated, which Madison says, well, hey, don't fear the federal government because they only have powers that are expressly delegated. And then as you move through Madison's thinking, it's like, well, I wrote my margins, so no implied powers. And as you move through the essay, you can kind of see Madison going, there might be some implied powers. And John alluded to the necessary and proper clause along with the supremacy clause. And so you kind of see Madison going a 180 on this idea. Well, maybe there might be some implied powers in there. And maybe with those implied powers, maybe these Bill of Rights, civil liberties, right, could be protected. And the other thing I think of as interesting is his advocacy for trying to control the states. We see that at the convention, and we see it in the arguments about the amendments he wants to get added to the Constitution. The ability of the national government to stop the mischief at the state level, especially in terms of conscience, which he was always about freedom of conscience, free press, as well as jury trials. Some things you definitely wanted to see there. And that's why one of the things I would teach with my students is we call the incorporation doctrine to the 14th Amendment, Madison's revenge. Finally, the ability of the national government through a different process, right? Of course, and we see this in Article 2, that Madison is saying, well, this Bill of Rights in the hands of a judiciary, since we didn't get the Council of Revision, since the Senate is not what I wanted, perhaps maybe this judicial review is a way to protect these rights if we get them in there. So I think you see all of these things in here. But again, throughout the article, I'm writing in the margin conjecture. This evidence not really heavy. I think the most powerful thing I think for me is towards the end, and it was from a letter by Fisher Ames, and who agreed that on page 465, first paragraph on 465, that Madison probably persisted because he had come to believe in a federal Bill of Rights. Congressman Fisher Ames, who agreed that Madison was inspired by politics, nevertheless divined that he was equally moved by principle and wrote that Madison was, quote, too much attached to his theories for a politician, end quote. And I think that's a powerful passage to maybe to defend Professor Lieberger's graduate student essay.
Any questions for Chris?
One of the things that is interesting to look at is Madison writes a letter to Edmund Pendleton on the 22nd of April, 1787. This is before the Constitutional Convention. And he says the crisis becomes more alarming as we get closer and closer to the convention. He says the issues facing them is we've got to get the convention to agree on a constitution on powers. We got to get Congress to approve it. That's under the Articles of Confederation. We got to get the state conventions to approve it. And then after that, we got to get the people to approve it. That's the issues facing Madison. And under all those, Madison is adjusting himself to the issue at hand.
One theme that I thought was interesting in Lieberger that I'd be curious to hear a little bit more about is how Madison comes to believe, maybe not in the abstract importance of a Bill of Rights as guard itself, but its impact on public opinion, because it prefigures Madison's other writings about public opinion and like the party press essays and things like that. So what do you make of the way Lieberger does or doesn't accurately assess Madison's thinking about the role of a Bill of Rights in shaping public opinion about rights and public views of rights?
I think one of the things that's interesting that he points out with Madison is that, and I wrote this in the margin in one of the comments I put down, no harm, no foul. So when he's proposing these, what Mason originally called milk and water or some Mason originally was like these are weak. So he's not putting and he says this, I'm going to put these out here, and really who could be against these things? And the other point he makes, I think, too, and he does it, Sam, he alludes to the idea, and back to that quote that I shared, that I think is pivotal in the idea of you have to get to make these documents venerable. You have to get the people to buy into them. And the people are not, maybe not fully buy into the Constitution if we don't attach some of these rights amendments to it. Now, part of that is political. Part of that is obviously stealing the anti-federal sunder. Part of that is obviously keeping the Constitution from a second convention. Part of that is fulfilling a campaign promise that he makes to get elected because of the Patrick Henry political machine that was Virginia today. But I think part of it too is to a degree, a sincere belief that the people um, the people will buy into these, the people will support these. And I think, and I think that one of the things Lieberger doesn't stress enough in his article is the influence of Jefferson. That's one of the reasons why I asked John this question, is because if you read the series of letters between Jefferson and Madison, you can see Jefferson wearing Madison down to a degree. I don't know if wearing down is the way to go. And finally, where Madison says, and I think Lieberger has this quote in the article, well, I never said I was opposed to a Bill of Rights. It's like, well, yeah, you did. Yeah, you did. So I think, but the idea of Jefferson saying, this is what the people are entitled to, and no government should rest on inference, that famous quote that Lieberger includes in the article. So I do believe, I think it is partly about winning the people over. I don't know if they're sure if that addresses your question, Sam.
Well, that's a nice transition to Dan. Dan, why don't you take us through Ken Bowling's article, "A Tub to the
Sure,
Whale," and then
sure. I'll take you through his article and sort of support it with the other documents to sort of make his argument for him. But sort of the broader context here, I think Madison is wholly a political creature, and sort of I'm not going to say he's philosophical at all. It's kumbaya. I think Madison was solely defending the Constitution and
so
preventing any.
tell us what you think, Dan.
I'm trying to hedge it. So you look at the threats that Madison was facing, right? He wants to keep the structural component of the Constitution. And as much as this is sort of ironic, privately, Madison is not a big fan of the Constitution either. In like an October letter after the convention in 87, he writes to Jefferson, blah, blah, blah. We didn't get this. We didn't get this. We didn't get this. But on that sort of public facing thing of Madison, he realizes the best thing that could come out of it. So he's seen as the most strident defender. He's preventing, the Constitution from being attacked by the addition of structural rights, possible calls for conditional ratification, the conventions, like the Harrisburg Convention, any circular letter for a second convention, and any other sort of efforts by Patrick Henry. So this gets to Ken Bowling's sort of article, Tub to the Whale. And the big thesis there is sort of captured in that title is the idea, and this comes from Mason's quote as well. Mason says, look, Madison is proposing this Bill of Rights, which is chock full of civil liberties rights and not full of the structural rights. What he is attempting to do is throw a tub to the whale, which means distract sort of moderate anti-federalists and moderate federalists as well, like Pendleton and stuff like that, Randolph, to go along with this in order for they to not really go along with the Patrick Henrys of the world to go after those structural rights. So that's what his article is about. And he goes through the different layers of that. And I think the articles that we picked out, or the letters that we picked out, can sort of walk us through the layers that Bowling does. But I would throw one step further. Where I hear this article used sometimes is that's the tub to the whale. And that's what Mason was going there. But I think Bowling's argument goes a little bit further. That the real whale that Madison was going after, that was looking to harpoon to death, wasn't just simply structural amendments. It was anti-federalism totally in opposition to the Constitution in order to defend it. And so with that in mind, let's sort of jump right in and think about that through the prism of Madison acting totally as a political creature. And if we go to that first letter from April 10th, 1788, he's writing here to Edmund Randolph, who, again, let's keep in mind, he was at the convention. He walked away. He didn't sign this. One of his bugaboos was the lack of Bill of Rights. And I think also in April 1788, Madison is realizing the political context of Massachusetts. Look what happened in Massachusetts in order for them to ratify it. And one of the big things that he talks about here is conditional ratification and the fear of conditional ratification, which would mean that if Massachusetts, which they debated in their convention, were to attach these amendments, then all the prior states that ratified up to this point would have to go back, reopen a convention to re-ratify the document, now including Massachusetts. And that just throws everything out. Madison wants to avoid that wholesale. The idea that if all we're going to do is attach these recommendations to the Constitution without touching the actual structure, leaving that alone, then then so be that. So in mid-spring 88, you begin to see a little bit of a transformation of Madison's thinking politically. If I can throw this tub out there, if I can just accept these recommendatory amendments, maybe that will be enough to stave off possibly conditional, as well as talks now of a second convention. And the fear of a second convention is, well, if you open that up, are they going to talk just solely about amendments? Or is this a Trojan horse? Look what happened when they went to Pennsylvania the year before in Philadelphia. They were given directions by their states. And now, this second convention could just be a wide open call to just throw out the entire Constitution altogether as a giant amendment and just start completely over. So that's why he's fearful of that. So he looks at this whole situation, and I think the political creature in him is looking at the second convention here to be dangerous. And if it even did happen, it would maybe result in maybe a worse created proposal than what the current one is, with many flaws. And that there's a practical and political challenge to all this as well. With those states that actually ratified it, what would happen to their, as he says, the local and personal pride? Would those states really want to go back and risk the chaos and resistance to sort of go through this again? So he says they probably wouldn't want to do that. And then the disunion argument, right? There's the fracturing of a fragile country. And keep in mind, we have the British that are in their forts right on our border. We have the Spanish, we have the French. So this union is a serious threat that he's worried about too. And so if all it takes is these recommendatory amendments, then possibly, he can deal with that later. But step number one is let's get this Constitution through first and foremost. Let's get it through first, untouched, and then we can maybe talk about that conversation. But let's not start gumming this all up because it could pull the whole thing down. So that's sort of where his thought is here. And I think also an important thing is all the letters here, including, or at least the first three letters, they're all in 1788, which I'm going to say is like the high watermark of anti-federalism. You have Massachusetts that sort of bookends this, and then you have like later on with Virginia and the second circular. But he's sort of looking at the original threat as this conditional ratification and calls for a second convention. So he's trying to prevent any of those threats from pulling down the Constitution in April 1788. I'll pause there if there's any additional comments or questions that before I go on to the next letter here.
I have one comment, Dan, for clarification. You just talked about the idea of putting these things within the body of the document.
Yeah.
And that was causing an issue for Madison.
Well, no, I didn't. I don't think I said that. I don't think I said where he would put it because Madison wanted them originally in the body of the Constitution.
Right. That was my. I wasn't sure what you were referring to in terms of throwing things into the body, because that's exactly what Madison proposes with his Bill of Rights.
Yeah, I'm sorry if I misspoke. I don't know what I said in that regard, but no, he'll later include those or want them included, not as additional provisions, but built within. And so it's like
that we'll get into that a lot more in our next session when we get to the issue of what Congress was doing with this post June 8th. I had a question, Dan.
Sure.
Your thesis is quite firm. I'm wondering, though, you essentially say he wanted to kill anti-federalism totally rather than just, you want the tub to the whale was anti-federalism. Don't you think it's a little ironic because like a couple of years later, he kind of is sort of in that anti-federalist vein. I mean, he's upset with the Neutrality Act. He opposes Hamilton's financial agenda. So I mean, I guess I'm pushing back. If he wanted to kill anti-federalism, not only was he unsuccessful, but he recreates it.
Well, anti-federalism, I guess, in the direct sense that it is a threat to the ratification of the Constitution as it currently is. And so the underlying sort of philosophical antecedents, that I think Madison changes with the times. I think, people like to say he's sort of a flip-flopper. I think he's doing whatever protects liberty. If that's the Constitution that best protects it at the federal level for those time periods and issues, then he'll go with a strong national government at the expense of states. Or once you implement this and you do get a Hamiltonian and you do get those programs, then he sees that the threat is from the national level and that the states, should have sort of a strong sort of pushback against that. So I think his common through line is protecting liberty. And at this time, he sees the states, as the major threat to that liberty in the Constitution, as the major protector potentially of that liberty.
Other questions for Dan or Chris or John?
One sort of question about the Randolph letter and a couple of things that follow on it in the Bowling piece.
Mm-hmm.
There are a number of events that could have impacted Madison's view. His own participation in the Virginia ratification debates gets only a few sentences in either of the two articles, like maybe a couple of paragraphs. Where would you place that pretty strenuous couple of months that they have to spend arguing in Virginia face to face with the Anti-Federalists as something that might have impacted Madison's thinking, because he had to confront and really grapple with the objections that people like Patrick Henry were bringing to the table?
Do you want to take it, John? Or no, Dan?
Oh, sorry. I was just going to say, I think that thinking is definitely illustrated in the letters on the 21st of September and especially the 17th October. I personally like the sort of what I'm saying here with tub to the whale is the reason why I think it gets minimized is that Madison is just really concerned with getting the Constitution ratified. And in that sense, the convention, I don't think rattles him too much. And during the convention, he sort of reiterates the standard Federalist points of why it's not necessary and defends that position. I think he looks at the political calculus coming out of the convention. I think that's what changes maybe his perspective is not so much the philosophical need for it, but the political aspects.
John, you want to piggyback on that?
It's uncertain in Virginia where the majority lies in the convention. No one knows for sure. The Kentucky delegates are sort of a wild card, and Edmund Randolph, another wild card. And Randolph has sort of his followings. The fact that George Washington doesn't stand for election to the convention, critical, because he might have pushed the Constitution over had he been in the convention. And so you have basically Madison, the teacher, the political scientist, the advocate of the Constitution, going against this gigantic power in Patrick Henry. And even though they decide to look at the Constitution clause by clause, which Madison would excel at, Patrick Henry goes beyond that and looks in generalities where he excels in that kind of analysis. You can just imagine the attitude that Madison has. In fact, there are 2 days of the convention. They meet from the 2nd of June to the 27th of June, so it's 1 month. There are 2 days when Madison is not in attendance. I think he's sick to his stomach. He's so upset over the burden that's on him to stand up to Patrick Henry. That's a real issue, and so he wants to keep this on a issue by issue, clause by clause basis, and in that kind of analysis, the tactician of Madison, the architect of each of these, he can excel. I mean, this is sort of the epitome that's mentioned in William Pierce's notes on Madison in the Constitutional Convention. He says, of all the people, all the politicians, all the delegates in Congress, Madison came best prepared. He knew more than anybody else. And in fact, what he would do is he would present his argument and wait with reserves. And so when the opposition came up, he had another 10, 20, 30% of ammunition in reserve to defend his position. And so that's the debate that's going on at that time. And Madison then realizes that in this close debate going on, uh, he probably is going to have to give up something. He's probably going to have to accept these recommendatory amendments. And knowing that this is not ideal, and in fact, he was opposed to them to a certain extent in Massachusetts, better than a rejection. Uh, Not so in New York when New York proposes its amendments, but with the circular letter calling for a second convention, Madison said would have been better had New York not ratified. And so Madison's sort of in between. Okay, he accepts recommendatory amendments, but let's steer clear of the danger of a second convention.
Yeah, and I think that's exactly where that letter to Jefferson from 21 September picks up, and that idea of let's steer clear of it and the dangers that that second or that circular from New York could open. And he says in there it rekindled the ardor among the opponents of the federal Constitution, and he talks about the possibility. But he also, in this letter, I think is important because he starts to see daylight between anti-federalists as well. He goes on to say that the views of Pennsylvania at the Harrisburg Convention aren't really the same views as, say, the anti-federalists in the South. And so he notices a division opening up between the two. And I think that division is something that he's going to exploit. And I think maybe the Bill of Rights is it's the issue that anti-federalists are sort of unified that they want. And he's going to turn it into the first wedge issue to actually divide the anti-federalists together, to cleave off sort of the leadership from the rest. And I think that's where Bowling is sort of making this argument too, is that Madison is pretty good at how he's going to manipulate this. And that gets to step one. How do I do that? Well, I'm going to craft the Bill of Rights, and it's going to be the civil liberties ones, not the structural ones. Civil liberties ones are going to be the ones that will attract most of those moderates, and they'll pull them away. And he sort of alludes to this concept in his last letter in October 1788, when he sort of has, oh yeah, my opinion has always been for the Bill of Rights BS sales job that I think he's giving here to Jefferson. But I think in a way too, he's speaking to Jefferson at that philosophical level to sort of schmooze him and sort of give him sort of the language and the conversation that they're used to. And then if you go into the reasons though why he's always been for the Bill of Rights, none of them are philosophical, right? He goes on to say, oh, I've been always for them, not because of that, because they're harmless political concessions. Why? Because I'm going to please the political opposition, which again, what does that mean? I'm going to take away the calls for a second convention. I'm going to take away the calls for a conditional ratification. I'm going to take away Harrisburg and the steam out of them. So he goes on to say, enlist political reasons for, and he goes, I favored it because I suppose it might be of use, and if properly executed, I think that phrase, he's sort of tipping his hat of how he is going to do it and what he's going to do. And then he sort of goes on that second page, and he talks about sort of how he's going to be a tool and in a means to create loyalty to the Constitution and counteract. And this is where it's sort of the whale part. What is he going to do? Why is he doing this on that second page? To counteract the impulses of interest and passion. And that's where he's going to sort of harpoon, wheel into, motion and strike the anti-federalists right in their heart with the issue that they wanted most will be their own death knell. And he goes on in a letter to Jefferson later on in 1789. He says, I selected these proposals, and Bowling has this on page 234. I selected these proposals that would extinguish opposition to the system, or at least break the force of it by detaching the deluded opponents from their designing leaders. So in many ways, that's sort of, the wedge issue that is going to quell the opposition and be the tub to the whale in so many words.
Well, Chris, is it at this point you invoke his June 8th speech as, come on, there's some sincerity in there, or
There's absolute
sales job.
Well, first of all, I don't know that Madison ever had to schmooze Jefferson. Let me just say that. Okay. And I'm going to go back a little bit because I think Lieberger's comments about Patrick Henry at the convention in Virginia, I think he used the word effusive, which I thought, wow, that's an understatement. Um, and Madison debating whether or not even to go because should I sit in judgment of my work? And I think I wrote the comment in the column in my margin. It was like, judge your work, go defend your work, right? You're not sitting in judgment of your work. Go defend it because you know what Patrick Henry is going to do, right? And I think so much of it, honestly, the recommendatory amendments coming out of Massachusetts, which then gets into New York, and I think the structural stuff really does scare them, right? The idea that, okay, and John alluded to this in his comments, that reserving the powers to the states and representation, regulating elections, direct taxation, monopolies, but you're not going to get into a lot of the individual civil liberties kind of stuff. So the idea that, as he moves forward, and I'm not disagreeing totally with Dan and the idea that there is a political side to this, and he is trying to winnow off some of these lukewarm anti-federalists, so to speak, by agreeing to perhaps to these, and he sees the political calculations of accepting these recommendatory amendments, or at least giving, saying, yeah, well, maybe we should consider them, especially after this circular letter in Virginia. But I don't know that. I think there is. I think if you look at that, the June 8th speech, which, again, Madison all 5'2" is very soft spoken. This is the one he gives. Is like, hey, come on, this is what we owe to the American people. I mean, he talks about the support for amendments, the necessity of adding a Bill of Rights to the Constitution, the absence of these protections in the original major concern for citizens and the states. He talks about the purpose of the amendments. The proposed amendments would safeguard the natural rights of individuals to prevent the government from becoming tyrannical. Majority tyranny, which is what he feared at the state and national level. The concern for overly detailed protections. The idea that, if we add too many specific protections, because that potentially limit individual freedoms or cause legal complications. And he talked about having these absolutes because and in Lieberger's article, he points out we know there may be time that we've got to suspend habeas corpus, or there may be time that so these rights aren't absolute, and the balance of between government power and individual rights. And Madison recognized the need to strike a balance between granting the government sufficient power to function effectively while ensuring that individual rights are protected from the government overreach. And Madison says that, he says in Fed 51, he says in a letter to Jefferson, he's constantly talking about the line, right? The line between government power, having too much power, where the government becomes tyrannical, and too weak because it won't be strong enough to protect our rights. So in short, Madison's June speech focused on explaining the importance of adding a Bill of Rights to the Constitution to secure the people's freedoms and maintain the proper balance of power between the government and the citizens, which actually kind of goes back to Sam's question about getting the people to buy into it. So in that speech, he relies on the people, he alludes to the people quite a bit.
John, you had comments?
Yes, I think the importance that Madison places in the danger from the majority, and that's the danger that exists in our American republic. Uh, Monarchies, you have the danger from the crown and that. In oligarchies, you have the danger of the minority ruling. But in our American republic, the danger is not the government, but it's the government action through the pressure exerted by the majority of the people. And so the people must be uh, limited in a certain extent, and that's the role that a Bill of Rights might serve. I'd like also to mention, Dan alluded to, I think it was Dan alluded to the Madison and Jefferson becoming sort of, or maybe it was you, Tim, becoming sort of anti-federalists in the 90s, as opposed to Hamilton. Jefferson writes a letter in 1799 to, I believe it was Elbridge Gerry, stating his principles, stating that he's not anti-Constitution. He's a supporter of the Constitution. And I think Madison is totally in line with Jefferson on this. Jefferson writes that his principles are those advocated by the Federalists during the ratification debate, not the principles that the what the anti-Federalists feared the Constitution might become. And so, when you're looking at Madison's point of view, he adopts the Federalist position in the ratification debate. For instance, the necessary and proper clause, that it will be limited. Hamilton advocates such a thing. And yet, when it comes to uh, the interpretation of that over the bank bill, let's say, Hamilton says the necessary and proper clause means that as long as it's not explicitly prohibited or not immoral or illegal, it's okay. The government can do anything it wants as long as it doesn't fall in those other areas. And so it's a totally different interpretation of the Constitution. So that Federalist interpretation during the ratification debate is important.
Sam?
Because one thing to echo what John was saying is that what happens for Madison is that it goes from a debate over the validity of the Constitution itself to a debate over what the Constitution means and how it ought to be implemented. And that's the great success, right? That you're not arguing about whether the Constitution is good or not by the late 1790s. You're arguing about who's getting the Constitution right. And that's the great transition. That's not really him becoming an anti-federalist. The sort of question I have is there a way to find a middle ground on this position and say that Hamilton realized or Madison realized he had to do something to tub the whale, but if you have to do something, you might as well do something good. So he tried to design a Bill of Rights that he actually thought was a good Bill of Rights. So we can kind of have a little bit of both authors here, where, yeah, he is engaged in a political maneuver to eradicate his opposition. But if he's going to eradicate his opposition, he might as well accomplish something else substantively useful in the process.
So he was sincere in his political motivation.
You know, you have to write a bill. You might as well write a good bill.
Yeah, yeah. That's kind of like can't we all get along theory.
It's one that won't be harmful.
Mm-hmm.
Yeah.
But I'd sort of say the bill that he wrote is essentially the ChatGPT version of the 1777 Virginia rights. He pulls them out, and then he goes on, even in his letter to Jefferson, it's been trampled over so many times. It's a parchment barrier, you know. I'm throwing something out there. It's good, but it's not going to hold up. I mean, these things have been shown to really not stop tyranny when the majority, to go to Professor Kaminsky's point, when the majority wants it, they can override it. And that's sort of that majority point.
John, I'd like to conclude.
Tim, hold on. There's another question in the chat from Deanne I thought we should get to.
Oh, okay.
And she said, when you say, I think this is, Dan, when you were speaking, when you say protect liberty, how is liberty defined? Seems like he was about protecting property ownership. Is that liberty? Is that his minority rights?
Yeah. I mean, to some degree. I mean, that's the sort of the commonality, the thinking at that time, that liberty would be attached to property ownership, and then his minority rights. I mean, I will say this, not to sort of put the cynic part away. I think he was sincere in trying to protect minority rights. He has a long history, like Chris, you alluded to, with the Baptists, and going back and writing, what was it, his
remonstrance.
Yeah. So I think there is a deep-seated belief in protecting minority rights, but the minority rights at the time, again, he's not talking about minorities in the sense that we are today, right? He's talking about those classes that would be the equivalent, but in different capacities.
Yeah, I would also, to dovetail with what Dan said, Deanne, I would check out Fed 10. I know we focus on Fed 10 for factions, but I think if you, my favorite part of Fed 10 is where he says, the first object of government is to protect the different faculties in men from which property arises. I mean, it really is a defense of the property class. And so, yeah, it's his property he's worried about. I mean, go back to, holy smokes, go back to Shays and other rebellions that we saw early on in the States. So that scare the bejesus out of those guys. So part of that's protecting their property for sure. And one other thing I want to point out too that Stewart really in his essay kind of makes me mad. He doesn't come out and use exact Madison words. He talks about where Madison at the convention realized there'd be a difference between the northern and southern states. That's not what Madison says. Madison says the states with slaves and the states without slaves. So Stewart kind of glosses over that. So I think in terms of property rights and what the southern states required, there might have been a concern about northern states at some point, not right then, at some point coming in, maybe limiting those property rights.
John, I'd like to conclude with I've been long perplexed by, and it's kind of come out here in Dan's treatment versus Chris's. In your estimation, is there a difference between the private letter, I mean, Madison's private thinking as revealed in these letters versus his public thinking revealed in, especially in the June 8 speech, if we take that at face value? Is there the private Madison and the public Madison distinction in your mind?
I think to a certain extent that's true, but one of the issues that I've always thought is important, but not often dwelt upon, is timing. And I think Madison is really quite concerned about that. The timing is important. He opposes a Bill of Rights when the Constitution is being debated, the ratification of the Constitution being debated, because the issue is getting the Constitution adopted. And I think too many times they understood that the process of amending the articles failed. There was an evolutionary process, and you go along that road to amending, and then something happens to stop it from the actual amendment taking place. And how they achieve a resolution sometimes was to go beyond that, as I indicated. So Madison is aware of that during the debate over ratifying the Constitution. We cannot let sort of side roads of amendments stop us, even though I might favor amendments, not structural amendments, but rights type amendments. Are they really necessary? And can they be divisive enough to kill the Constitution? But once the Constitution is adopted, now that's a different ballgame. And so you have a solid Constitution that can be amended. The danger then structural amendments, as we've talked about all along here, but the rights type amendments, getting to that letter that I alluded to, 1799 letter, what the fellows were saying, the rights are not necessary to put them down. We have these rights. Madison references in that speech, he says, we're used to having these rights. And when you see the debate over rights at this time, they're not very detailed. When we look at freedom of the press today, freedom of speech, these are difficult concepts. Where do you draw the line? There was no analysis of those rights back in 1787. They knew what they meant. At least they thought they knew what they meant. It was pretty clear to them. These things had been debated and discussed, and they were in the common law. And so there was a sense of we all know what these rights are. And do we need to put them down in writing? They're there. And so if we do put them down in writing, they won't hurt for the most part. Madison says, what might they hurt? And there were a couple suggestions there. And he says one of the most valid is if we list some rights, will other rights not listed be in danger? He says that's an important point. I sort of agree with that. And in looking at the ratification debate, I think that there are only a couple references to that concept of we need to protect those rights that are not listed. And that's what the Ninth Amendment does, is Madison adopts that version of protecting rights that are not listed by including that in his amendments. And so I think I was going to present some other argument too that he puts forth. It skipped my mind right now. Uh, but
John, oh,
go ahead.
sorry. I was just gonna say, thinking about timing, and the first article that, or the first letter that we selected, Madison is writing to Randolph, right? And I'm trying to read this letter. Is Madison being sincere? Is he trying to essentially like lay out the fears of non-ratification for Randolph, so then Randolph will tip the scales to want to ratify the Constitution when they get there in June? Is he laying sort of that groundwork to try to influence Randolph at all in those letters? Is that the motivation?
Oh, absolutely. Madison understands the importance of Randolph. Randolph was governor of the state, a young man, dynamic, excellent orator, and in a letter that he writes to Randolph in April of '87, he says, uh, I'm glad that you're considering this new convention that's coming up. I wish you would consider it more, and it has forced me to consider the issues more myself. But Randolph, when he refuses to sign, he advocates a second convention, and his second convention is different than most other second conventions. What Randolph is proposing is that all the state conventions propose amendments, whatever they want, and they're sent to the convention. And this convention will be an end all. That is, the Federalist fear was that to be one convention after another. The convention proposes amendments. Some of those are accepted. There'll be another convention to propose more amendments, et cetera, et cetera, et cetera. But Randolph says no. State conventions propose amendments. They're sent to a second convention. The second convention is the final arbiter. Any that amendments that are accepted by the convention, not going back to the people, but in this second convention, if they're accepted, they're part of the Constitution. If they're not accepted, they're dead. They're not to be considered. And so that's Randolph's point of view. Obviously, Madison finds that quite dangerous. And so he realizes the importance of uh, Randolph. Randolph is forced to write a letter explaining his position in not signing the Constitution. He dates that in October, I think October 10th of '87. It's not published until the 27th of December, published in a pamphlet form. And he says, Randolph says, I'm basically uh, in favor of these amendments unless it endangers the Union. If it endangers the Union, then I will oppose anything that endangers the Constitution, endangers the Union. And so that's what Madison sort of seizes upon. He realizes the importance of Randolph. And when Randolph gives his first speech in the Virginia Convention, coming out in favor of the Constitution, the Anti-Federalists labor him as the modern Benedict Arnold. He is a turncoat here. He's against us. Well, it becomes, I think, the critical person in the Virginia Convention. So Madison realizes the importance of Randolph.
Well, with that, if you need to go, feel free to go do so. A reminder: if you don't want Volume 1 of our Bill of Rights series, let us know. If we do not hear from you, we will send it to. There you go, Chris has it. And so yeah, and if you want a CEU letter, let us know about that as well. So you're free to hang around. We'll probably be here another 15 minutes or so. But if you have to leave, we will look forward to seeing you in a couple more weeks. Chris, you had something?
Oh, I just two things before everybody takes off. John alluded to this earlier for folks that are teachers. The founders on the founders. If you're not familiar with that, that your students will love because that's the founders dishing on each other long before there was social media. So that is what did they think about each other? Really think about each other. And go to the website, and it's fantastic stuff. Go find the description of Thomas Paine towards the end. Oh my God, that's brutal. It's a brutal takedown. That basically, if the jackals on the plains of Africa came across his body, they would turn away in disgust. I mean, these are, but your kids, your students may like that because it's just dishing the dirt on each other. And I'm just happy to hear John give a shout out to the Ninth Amendment there too. I just wanted to get that in.
I'll put the link to the founders on the founders here in the chat for everybody.
Yeah, when you look at that on the website, you got to get to the end. You go to multimedia, I think it is, and there you'll see a reference at first to the book edition by the University of Virginia Press. You go down a little bit further, and it's the complete database,
Yeah.
and it's indexed, and so you can click on the letters of the alphabet, and it'll get you access to all of the
Yeah. Here it is. This is what it looks like on our website, and I just sent the link in the chat for everybody.
Yeah, so there's the book edition, and then down a little further is the index to the full database.
Yep.
And in fact, I'm still finding things and adding to it. I alluded earlier to Gouverneur Morris as being immoral. I just saw that today in a letter from Arthur Lee in talking about Robert Morris and his immoral assistant in the Office of Finance in 1781.
Other questions or comments?
I do. With the bowling article that kind of set off this cascading, like, kind of stream of consciousness of thought. And I was kind of thinking about, like, if that's true, that, the tub to a whale, or like Madison is like jangling his keys in front of Patrick Henry, like, hey, look at this. Like, could one argue that, like what's in the Bill of Rights, what we usually teach is like, this is the core of the United States. These are the things that we believe. If Madison's using that as keys, is it actually that foundational to the United States? And then I think about, like, what would, an originalist like say about that, where they're like, if they take that information and then they could be like, oh, maybe the parts of the First Amendment aren't actually that important. Or what would other like designing men do with that type of interpretation? So I don't have an answer. I just kind of wanted to throw that out there and kind of see what we thought.
Well, Chris, I know Chris well enough I mean, there's an argument that it doesn't mean anything till 1925. Would you agree to that, Chris?
Yeah, Tim and I were talking about that earlier because if you think about it, and this is a kind of, and Mike, to your point, but tangentially, we know that Marshall is just the nationalist, right? Marshall is, as Chief Justice, he's making these opinions. I'm thinking of Gibbons v. Ogden, that kind of thing. But he doesn't in Barron v. Baltimore. And so in Barron, when he basically relegates the Bill of Rights as a protection only against the national government, states are free to trample on the rights of citizens until we get the idea of the 14th Amendment incorporation. And of course, we don't see that really working for truly individual rights until Gitlow in 1925. So yeah, I mean, we think of the Bill of Rights, and I agree with you that we teach our students what makes America different, and they all want to say our rights, and it's like, well, those really weren't important for a long period of time.
I
And
think
originalism is just, anyway, don't get me started on originalism.
Does that answer your question, Mike, or you have a follow-up to that?
Yeah, that's like kind of the exact line that I was thinking of yeah, like I grew up that way, that teach about like the Bill of Rights and um even thinking about like Second Amendment stuff and be like, oh, it's really not that important. Uh and then like what would like the NRA like say to that and but yeah, that's just kind of a lot of stuff that was rolling around in my head. But yeah, thank you for that answer.
Well, case in point is the Alien and Sedition Act, right, which both Madison and Jefferson felt was unconstitutional. But that First Amendment that Madison championed, that didn't do much to protect that freedom of the press and speech. So, was it a parchment barrier? I don't know.
I do think the only useful argument that you can sort of roll out is that there is a difference between a legal effect and a cultural and a political effect. And as Lieberger points out on like, page 455, 456, or 57, there's a cultural effect of the Bill of Rights that other states, when they begin to write their constitutions and they adopt Bill of Rights, those states look to the National Charter of Liberties when Americans talk about what liberties they think are valuable in political debates in the 19th century. When you look at Lincoln, he's looking at the Bill of Rights as something that he sees as a set of value statements. It's definitely true that they don't have much of a political or much of a legal impact, right? There's no Supreme Court striking down federal and state laws on the basis of the Bill of Rights to go off of, but that doesn't mean they don't shape what Americans think about the rights they value.
Which, Sam, makes me wonder, had Madison been successful at getting that very Lockean addition in his original proposals to the beginning of the Constitution? Lieberger addresses that, but it's very interesting to take a look at what Madison originally proposes. Very Lockean in its concept about the people and the power of the people and the idea of consent, how that might have changed as we've fulfilled our manifest destiny and right to left American history as states were added. That would have been interesting.
It makes me worry that it might have given a sheen of legitimacy to the Confederacy, and that's not something anyone would want.
Right.
One of the arguments that Madison uses in his 8 June speech is that if we had pursued amendments, one of the dangers is that perhaps the rights that we knew from our heritage would be limited. That is, freedom of religion. If we put that provision in an amendment, a provision of the Constitution, the Northerners, the New Englanders in particular, would interpret that to have a limitation. It wouldn't be so broad as the freedom of religion in Virginia. And so the concept of freedom of religion before the First Amendment is very broad. It's just not spelled out specifically. And that's true of all the amendments that are in the Bill of Rights. Madison and Jefferson would argue that they're there already. They're part of, Madison alludes to that in, again, the 8 June speech, the great rights of mankind. Not just in his proposed amendments, but these are the rights that are protected before the U.S. Constitution, the great rights of mankind.
So, quick question here on the New York Circular. It's written by Hamilton and Jay in Lansing. Why would Hamilton and Jay be a part of that and advocate essentially for a second convention?
It wasn't that they particularly were advocating it. It was part of the deal to get ratification. Remember that in the election of delegates to the New York Convention, 2/3 of them were anti-Federalists. And so the Federalists faced a mighty hurdle to get over that. And they did ratify eventually by a majority of 3. And so it was very close. But one of the prices they paid was to support this circular letter calling for a second constitutional convention. And for some reason, it was decided to give the shore to writing this to at least two fellows, Jay and Hamilton, both excellent writers. So it was the price that they had to pay to get ratification. Madison said it was too high a price. It would have been better not to have New York ratify than to get them advocating a second convention. So they didn't do it willingly, Jay and Hamilton. Uh, I think maybe they thought they could perhaps tone it down a bit, and it wouldn't be a fiery letter that might be more appealing. So I think that's why they consented to be part of the authors of such a thing.
Political expediency.
That's what I mean. I think of this whole process is this and I said this from the jump that Madison is what a Politico, and the politics behind all of this stuff. And you think about Henry trying to maintain control of his machine in Virginia. You think about these guys in New York trying to maintain control, and the politics of the day is really not much different than the politics of today is really not much different than the politics then. And I even in the one of Ibert's things says the next battle would be to elect Federalists to office. Now, for the first time, by advocating amendments, Federalists would be strengthening the Constitution, not helping its enemies to destroy it. And I said, kind of like the Dems in the Senate voting in favor of the CR yesterday. I mean, I see it in a weird way. I see a correlation there.
Sure.
So this is politics.
Well, Robert R. Livingston, who's one of the leaders of the revolution in New York, a very close friend of John Jay, sort of reluctant rebels in a way, he expressed the concern that what their group, their leadership group, it was important for them to lead the mob in the right direction, so that the mob wouldn't go overboard here, and sort of control it. And I think that's probably what Jay and Hamilton were thinking when they agreed to author the circular letter. Let's do a little bit of leading here and sort of stifle the extremes on the other side.
The excesses of democracy.
Okay.
Well, that kind of wraps everything up here, I think. Unless, well,
Hey,
actually,
Tim,
I
Tim,
have to. Yes.
can I say something, Tim?
Well, I don't know. Sure.
Well, thank, it was so great to hear John Kaminsky again. I would
Oh,
recall,
stop sucking up. Stop.
yeah, I know. I recall the first time I met John in North Carolina at a Cradle conference and thought, wow, I could just sit there for hours and listen to this man talk. And I've enjoyed that over the years. But it was a nice refresher today. So thank you, John, for spending your time with these teachers today. And it's great to see Sam and Kelly and all of these other folks that I don't know paying attention to this important topic. And Chris, you laid it right on the line at the very end is, those guys spent, you're a threat to democracy on each side. And things seem to not have changed much, or it's part of human nature, which we could discuss more. But thank you, Tim, for putting this together. And again, great to see you, John. Thank you so much for your lifelong venture into understanding the constitutional, and more personal than I think any of us know. So I'm sorry, Tim. It's great to see everybody.
Yeah.
Thanks, Bob. My connection with you over the years has been really very important to me, and I highly value it. And you have been a terrific asset to the program, the civic education program. So thank you, Bob.
Well, I mean, I mean, in a sense, John, Bob is the matchmaker. We met each other because of Bob. So,
Yeah, that's true in Bloomington.
yeah, so you can either credit Bob or blame Bob for that.
And Chris as well, too. That's where I
Yeah,
met Chris.
right. Yeah.
Kelly's going to try. She's trying to take off.
I just wanted to say thank you very much. I really appreciate you guys'
Sure.
time, and I always learn so much. So thanks. Have a good weekend.
See you
too.
later.
Yeah, I'm gonna head down too, gentlemen. Bob, it's always great to see you. I don't know, it's definitely. And Dan, you were close. You were close a couple times. Blah blah blah, schmoozing.
I'd say he laid that out. He put a good whoop ass on your head.
Well, I didn't pull the short end of the stick here. I mean, Chris pulled the philosophy part, so he made a very good effort.
Swing and a miss. Oh my gosh. Says the young buck. I love that.
Well played, Mr. Haas. Well played. All right,
Appreciate it.
gentlemen, have a great weekend. Robert, good to see you.
All right, take care, Chris.
Bye-bye.
I got to scoot too. I'm meeting one of my sons here this afternoon. So
Badgers play in 3 minutes, so
yeah, I know. I said that too. See you later,
take care,
guys.
gentlemen.
We'll talk Monday, John.
Okay,
Okay.
bye now.
Bye-bye.